Well, I was just moving on to the final aspects of our appeal on our primary case. And if we can go back in the judgment, so that's core bundle tab 7, if it's still in there, your lordships and and it's paragraph 58. And this is where the judge, in the common general knowledge section, has come back to on-off keying. And it's particular in 62, where he's dealing with the issue of the terminology points, where he refers to a textbook by Homer and Scala on HSDPA, HSUPA. And he says it was published in May 2006, but Dr. Moss accepted it is still what the skilled person would have known at the priority date. And what that book described was a system in relation to HSUPA, where certain feedback was given and used, at least in part, used on-off keying. And it may be just easier to show you the book itself, just briefly, rather than the judge's short description of that. So that's supplemental bundle and tab 7. And I think you'll need the original one for that if you haven't got the updated version. And so the section starts, chapter 5 of the book starts on page 69 of the bundle. But if we turn on through the document to page 70, page 80, section 5.3.5. So this is bundle page 80, original document page 72. This is dealing with something called the HARK indicator channel. Now, HARK, I perhaps too early this morning said that we don't need to worry about any other kind of control signaling. Very briefly, HARK is a mechanism whereby every time a packet of data is sent by one end or other of the network, so sent by the transmitting end, in this case the UE, the receiving end attempts to decode the data, and if it decodes it successfully, it sends back a signal that's referred to as an ACK, an acknowledgement, which means, yes, that was fine, carry on. Or if it doesn't decode it properly, it sends back a NACK, a non-acknowledgement, which means, sorry, I didn't get that properly, can you try again? And HARK is that process by which that happens. And so this is HARK in HSUPA, so it's the UE sending the data to the base station, and it's the base station sending the ACK and the NACKs back to the UE saying yes or no. The first paragraph, it describes the E-hitch as a new downlink channel for transmitting positive and negative acknowledgements for uplink packet transmission. If the node B received the TTI, the transmission, correctly, it will respond with a positive acknowledgement. If it received it incorrectly, it will respond with a negative one. The E-hitch information is BPSK modulated with on-off keying, and the modulation depends on which cell is transmitting the E-hitch. If it's coming from the radio link in the serving radio link, then both ACKs and NACKs are transmitted. And then it says if the E-hitch transmitted by a node that do not contain the serving cell only transmits ACKs. If such a cell doesn't receive the TTI correctly, then it does nothing. The UE will continue retransmitting until this one cell returns with an ACK. So if we look at the table in 5.
So just to make sure I've got a picture in my mind about what's happening. You've got a phone and you've got a number of separate node B's base stations.
Yeah, so this is soft handover, my lord, if my lord remembers that from any other previous case.
Yeah. And it's so it has a what you might call a close relationship with one base station, and then it also has other base stations that are listening to it. And that's what the serving one is the one it has the close relationship.
Yes. And the other ones are the ones it's communicating with, but not quite so closely. And if we look at the table 5.6, we see if the rows in the table, if the TTI is received correctly, the logical response is an ACK, and the serving cell signals a +1, an ACK, if it gets this, as does the other cell. But if it's not received correctly, it's only the serving cell that sends the NACK. The non-serving cells do nothing. And that's why there's the reference to
DTX means do nothing, does it?
Well,
Doesn't feel like nothing.
it stands for discontinuous transmission, but what it means in the jargon is don't transmit anything.
Okay.
So then just looking, perhaps with that in mind, then looking at that second paragraph again, the EHITCH transmitted by the no-Bs that do not contain the serving cell only transmit ACKs. If the cell doesn't receive it correctly, it does nothing. So that's then recorded in the table as DTX. So when it refers to the information being BPSK modulated with on-off keying, on the non-serving cell, the on-off keying is you either send the ACK or you send nothing, but sending nothing means I didn't get that properly.
Is this one-off keying in the wider meaning of one-off keying?
What it is in at least one sense, if not two. It's definitely in the sense that this is CDMA, so there will be a spreading code being applied. So what's being sent will be a symbol that's been spread with the spreading code for transmission in CDMA. It's also in the sense that the ACK is a +1, so it's a BPSK modulated symbol that's either sent or isn't sent. And not sending that symbol is equivalent to the information being sent, and that's an ACK.
So the phone doesn't have to decode anything, does it? Apart from the spreading code?
No. Okay. Because from the non-serving cell, it doesn't have to decode anything. If there's energy there,
Why is it bother calling it +1 then?
well, because there has to be a symbol that has to be multiplied by the spreading code to get something to be transmitted.
Mm-hmm.
And it happens that what they do is they have the +1 symbol as the one that's sent. The reason why it's called on-off keying is because if
I understand. Well, it's called on-off keying, presumably because it doesn't send something if it would have sent a NAC.
yes, but it is
only applies to the non-serving.
only the non-serving cell. So the serving cell is saying positively, I didn't get that. The non-serving cell is saying, I didn't get that by doing nothing.
Yeah.
So,
as far as the phone is concerned, I'm just looking at it, it may not matter, but just to help me understanding it, because sometimes you think, well, that sounds very strange, why do you bother? The point is that the phone is trying to send the information, and so if it gets an ACK from anybody, it knows that the system has heard it and acknowledged it okay. But getting involved in hearing negative acknowledgements is complicated if it's starting to get them from anybody other than the serving cell that it's trying to talk to.
yes, I suspect there's also an element of reducing the interference as well by just not transmitting things unnecessarily. So that was the example, and
Presumably, sorry, Mr. Hitchley. Presumably the point is that if the phone receives a negative, in other words, a NAC, and I didn't hear you from the serving cell, but it does receive an ACK from one of the non-serving cells, then it knows it doesn't have to bother trying to retransmit the thing.
yes, because obviously the cells are all connected in the
And
network.
if they all started sending both of those, it would all get quite complicated.
Yes. There had been a dispute about whether that was really, this example was really on-off keying, and that arose from Dr. Moss's view that on-off keying was just sending the sinusoid without anything extra. The judge resolved that against it. So this was an example of on-off keying. And as we say, when you turn on to paragraph 71 of the judgment, where the judge says in the last sentence, the skilled person wouldn't have been aware of any use of on-off keying in any cellular network implemented at that date. We say the fact that it was used in HSUPA, in a situation where the judge accepted the skilled person would have known about, is inconsistent with that finding. Of course, this is not just any old historic system. This is HSUPA, which is the most up-to-date system there was prior to LTE, and it's the very one we've obviously been talking about as far as scheduling is concerned. So if we go on in the judgment to 170...
Sorry about the noise outside. Is this example of on-off keying in this textbook an example of the kind of on-off keying which the claim claims?
The claim would cover this, yes. Okay. Because it's the presence of the signal means that it's an act in this case.
It isn't exactly the same as the LTE system, is it? Because this is 3G, not 4G.
This is 3G.
Yeah.
Yes. But in LTE, there still has to be a symbol, has to be modulated, that's transmitted.
Right.
Yeah. And I mean, I think from recollection, the LTE standard doesn't specify which one is transmitted at this time because it doesn't matter. All that matters is there is something transmitted.
Okay.
So if we go back to paragraph 170 of the judgment.
Sorry, can I ask you, this is probably my lack of understanding, really basic question on 71. The judge says OK would have been viewed as having no application as a means of transmitting data and very seldom used to transmit control information. Not being used to transmit data in the book example.
This is control information.
It is control information. Yeah, so what's wrong with what the judge is saying at 71?
Well, it's the last sentence. We won't have any use of OK in a cellular network implemented after that date, because although it wasn't used in HSUPA to encode the actual user data that was being sent on the data channel, it was being used, at least in relation to the HARC control data on the downlink.
Had it been implemented at that date, at the priority date?
I don't think there were HSUPA networks.
Well, that's what the judge is right there, isn't it? Doesn't that demonstrate that the judge is actually precisely accurate? To say that it's not been aware of a use of it as implemented at that date, that's true. If this wasn't implemented, I mean,
don't understand that was the point that was taken in relation to this aspect.
Well, wait a minute. But you're saying the judge is wrong, but at least as far as I can see, the judge isn't wrong, because that example may well be an example which you say is common general knowledge, and there's a point about the word known and whether that's good enough. But it might have been, it's perfectly possible for something to be known, common general, and let's take that as common general knowledge known, but also one that was known as part of a proposal which hadn't yet been implemented, in which case there's nothing wrong with the judge's finding at all.
Well, except when the judge comes back at one, so
maybe there's a point coming later, but at this point there's nothing wrong with this paragraph.
No, except that in 170, my lord's right, although of course it really wouldn't be a valid distinction because the skilled person knows about the systems that have been developed.
Well, I understand.
The fact that it wasn't physically rolled out because it takes a couple of years for the network.
Well, maybe, but your point is you're saying that this is a finding which is incorrect.
Yes,
and
but
I'm not sure that it even is incorrect, even taking everything else that you're saying as being right.
But my lord, if we go on to 170, when the judge restates it, this time round, in the second sentence, he says he would not have been aware of OK in any cellular networks developed. So he's not making, at least when he comes back to it on obviousness, he's not making the point that OK is one that had been standardised but hadn't yet been rolled out. He's talking about developed here. So I think my lord's right strictly on the wording that the judge used in 71, but I don't think that's what he was meaning, the distinction he was meaning to draw. And as we've seen already in 170, that the judge recognises that the skilled person could, in principle, have had their attention drawn to the scheduling request option of B in Samsung. But of course, they would have had to have focused on that for a UE that had no resource, and that OK could have come to mind, and so on and so forth. And he goes on to explain there'd be no significant barriers to that line of thinking. And what we say is what the barrier was in the judge's analysis was the fact of his finding that OK, his skilled person wouldn't have been aware of it in any cellular network developed by that date. And of course, we say that given that that wasn't the case, because it had been used in HSUPA, once you take that roadblock away, there's nothing then left stopping the skilled person following the line of thinking that the judge describes in the second half of 170, and that should lead to the conclusion that used it.
I mean, am I right in thinking that it was never suggested or put that for the point that a skilled person given Samsung would then think of this specific technique? That was never part of anybody's case. You weren't putting that. I haven't read every single piece of paper in this case. Well, I've read what you've given us, but I know there's a whole lot more material in this case I haven't read.
I think to be fair, that was used as an example of why OOK was a
Well, I understand.
common general knowledge technique. It wasn't specifically, there wasn't a specific link with you will read Samsung and you will
You'll think of this part of HUS. Yes, fine.
now, I'll deal very briefly with three of my learned friends' responses to this. The first one is he says, well, when I say this, I mean the judge's discussion back in the common general knowledge section in paragraph 62 was in the context of a dispute about terminology, not about what was known. And we say that's just a distinction without a difference. The judge is plainly referring to what the skilled person would have known as a way of getting at the terminology, but he's always dealing with what the skilled person would have been aware of. The second one is the point my Lord Justice Birss alluded to a moment ago, which is what is meant by the word known. And my learned friend takes a point that in cross-examination I put that question to Dr. Moss, and I didn't use the words common general knowledge. Now, that, we say with respect, is not a good point, because Dr. Moss had agreed that the HSUPA standards were the source of the skilled person's common general knowledge. So if we, just to make this point good, we go to the amended supplemental bundle, tab 3. And it's the page 43A. There's a heading just above the bottom hole punch, sources of the common general knowledge. And 29, he refers to another book by Holman to Scholar. Now, just to be clear, that's not the book we're talking about, because that was the UMTS book.
I got that one.
Don't we all, by the way? And although Mr. Birkin's got my copy, but it's paragraph 30. The skilled person would have considered HSDPA and fundamental concepts of HSUPA as the current state of the art at the priority date, and they would have had access to the 3GP specifications at the priority date. So, as is common in these cases, acknowledgement that the specifications, the standards record the common general knowledge of the skilled person. And so, given that this system would have been set out in the standards, when I asked Dr. Moss when he agreed that would have been known, that was a perfectly legitimate way of getting to the issue of common general knowledge, because the common general knowledge were accepted the standards were accepted to be common general knowledge.
Presumably the reason that the witness there says would have considered HSDPA and fundamental concepts of HSUPA, the reason for the qualification relating to UPA, fundamental concepts, is because by the relevant date, the downlink HSDPA was implemented, but the UPA wasn't implemented. That's presumably why he says what he said.
And the last point they make is that neither expert thought this was a good example of on-off keying. And in relation to that, well, Dr. Moss's reason why he thought it was not a good example was he didn't think it was on-off keying at all because of his sinusoid points. But the judge didn't agree with that. And then Professor Valenti, what the judge recorded, what his evidence was at the end of 63, at the top of page 87 of the judgment, he thought it was a little complicated and not the best example. And that's just the professor saying, well, it's not the simplest example of all. It isn't that it isn't on-off keying.
What if it wasn't identified in the standard as one-off keying, but is only called that in the book? Do we even know if that's the case?
I can't tell you, Your Worship, what's off my head. But if that is the case, it is on-off keying in the judge's description, because it is
Oh, I understand.
it is sending something to signal one thing and not sending it to positively signal another. And it is the way that it was described in that book. I don't think there's I don't think whether doctors or professors Holmer and Toscano are using it idiosyncratically, at least not in the judge's finding anyway. And the final point that InterDigital make against on this aspect is that this is a downlink transmission, not an uplink one. We say that's just a distinction without a difference. So, my lord and my lady, that's all the points on the primary case. And so what I was going to do now is move on to the secondary one. And just a couple of initial observations about that. The first one is this is an argument based upon the judge's finding as to the teaching of the Samsung prior art. It doesn't rely on any issues of what's holy or any points like that. It's a straightforward obviousness argument. The second point is just to explain the terminology and why it's called the secondary case. The reason why it's called that is because in his first report, my expert, Professor Valenti's evidence was that one obvious way for the skilled person to proceed was to reduce the size of the message to 1 bit for the reasons that we've been through. And as we've seen, Dr. Moss's evidence was that the skilled person would interpret Samsung as and would think that you would need the 18 bits of the message from HSUPA. Now that prompted Professor Valenti to reconsider the requirements of the claim in the light of that evidence. So that was the first time he'd obviously seen Dr. Moss's evidence and seen where he drew the line on obviousness. So can I show your lordships what Professor Valenti, what he said in his reply on this point, because it explains the point in a clear way. So this is the amended supplemental bundle tab 5. And if we go to page 59, and we pick it up at 98. I'll let you have that. He starts off referring to what Dr. Moss had explained. In fact, and halfway through, in fact, the skilled person reading Samsung would think the message would have been one that had been encoded message sent by the UE, including with it the scheduling information. And Dr. Moss relies upon reading this as the basis for patent being not obvious. And then in 99, Professor Valenti explains that he agrees it doesn't specify the precise nature of it, and he deals with the routine ways it could be done with below. However, even if the skilled person interpreted the reference to EDSI-like message as being limited to a message that contained only the same type of information as the SI defined in HSUPA, I believe that would still satisfy the requirements of integer 1D of the claim. And then he goes through the bits of the patterns that we looked at this morning. This is paragraph 37, and the various options in that. And then in 102, when sent in the circumstances of option B of paragraph 3.2 of Samsung, i.e. when the UE needs to ask for uplink resources, a message that contains the same type of information as the HSUPA SI, essentially how much data to send, will be a message where the presence of the message will be an implicit request for uplink capacity, and the contents of the message will be providing extra information about the request. The HSUPA SI message does not have an express scheduling request bit or field encoded within it. So that's the argument, and as I said, it arose from Dr. Moss's interpretation of the Samsung prior art. So if we can pick up where the judge deals with this, and actually first of all we need to go back to paragraphs we looked at this morning. So back to 165 of the judgments on page 105 of the bundle. And so this is where the judge starts dealing with the primary case. But what he's also doing here is dealing with what Samsung teaches. And in particular, it's paragraph 167. The starting point, considering the EDCH-SI-like message of option B, would have been to think of the familiar message from HSUPA. That was an 18-bit message containing scheduling information, and without a bit, identifying the message as a scheduling request. That function, which is the function in HSUPA, was provided by the happy bit sent on the other channel. Option B, that's option B of Samsung, indicates that its proposed message is not the same, in that sending the message serves as the mechanism for asking for uplink resources, although that could be done by a signal within the message. So what the judge is saying here is what Samsung is telling the reader is that it's option B, the message sent on the non-contention based channel, is sending the EDCH-SI-like message, but it's different from HSUPA because it's the sending of the message that serves as the mechanism for acting on the uplink resources. But as an alternative, there could also be an extra bit inside it saying, I am a scheduling request. Now, of course, we say that's precisely the same as one of the options in paragraph 37 of the patent. If you just go back to that, so that's in the supplemental bundle at tab 2.
So which is the same?
So what the judges, the first, so when the judge says option B indicates that the proposed message is not the same as HSUPA, in that sending the message serves as the mechanism for asking for the resources. That option is the same as paragraph 37 of the patent. The last clause of the judge's paragraph, although that could be done by a signal within the message, is also in paragraph 37, but is not the one that's claimed.
But you say that's an alternative. You say that's expressed here as an alternative. Different option.
Yes. So the judge is saying that what Samsung is teaching, well, no, actually, sorry, my lady, not quite right. What the judge is saying Samsung is teaching is that sending the 18-bit message on its non-contention channel serves as the mechanism for asking for the resources. And then his last clause, although that could be done by a signal within the message, is saying something another obvious way of doing that.
So you're saying the first bit is contradicting himself to what he's saying elsewhere in the judgment.
When we get to the end, when we get to his analysis of the secondary case, he overlooks what he'd find Samsung was teaching. So I was just going to show you back to the patents. So back to core, supplemental tab 2. And paragraph 37, so that's page 9 of the bundle, and it's column 9 of the patent. So it says, as we saw earlier, maybe a burst transmitted by one of the UEs on its respective non-contention channel requesting an allocation of uplink physical resources whereby the presence of it is indicative of the resource allocation. It then goes on to talk in the next sentence about the non-claimed alternative of having a bit saying 0 or 1. And then it's at line 15, the burst may also include information related to the resource allocation request, such as the amount of uplink data you transmit, the priority, so on and so forth. And as it was...
Is that actually the same? What I'm thinking about is not from the perspective of the sender, but from the perspective of the receiver. So I can see how what the judge is saying is that he's concluding that Samsung indicates that that in sending the message serves as a mechanism. As I understand what this is saying, it's saying that you send the 18 bits in the non-contention mention a bit of the channel that's yours, and that's your way of asking for resources. But if the way in which the receiver interprets the message is by decoding it and reading the 18 bits in order to understand that it's a scheduling request, then that's not the same as the patent.
Well, no, because the patent still has to, if you take the option of the patent where you have the burst, the presence of which
Yes,
is indicated,
exactly.
but then you have to decode the contents of it to find out how much.
Yes, that's different.
Well, no, with respect, no, it's not. It's exactly the same.
It's different because it's different in what the receiver does. What, as I understand, the patent is requiring is the receiver interprets the presence of the burst itself as the scheduling request, and it can then decode the burst and derive information from that which is relevant. That's what the patent's talking about. But what I'm not clear whether, I mean, the judge isn't, I don't suppose, was concerned about it, but it seems to me that it's at least potentially what's going on here. There's a distinction in the context of how you receive the information between interpreting the presence of the burst itself as an indication of the scheduling request and a situation in which you don't interpret the presence of the burst at all. You decode it and interpret the presence of the bits as a scheduling request.
But when the judge says in that sentence,
I mean, it might be some other. There's all sorts of other possible things that could be going on in this.
when he says the proposed message is not the same, he's saying it's not the same as the message in HSUPA. And of course, in HSUPA, that was sent at the transport layer on the shared data channel, and that message did need to be decoded.
This is the happy bit.
No, this is the scheduling information.
But isn't the point that the happy bit was sent separately, and that
The happy bit was sent separately, but the judge is talking about when he says the proposed message, that's the EDCHSI-like message. Its proposed message is not the same. It's not the same as the message that was in HSUPA.
Well, but is that because previously the function was provided by the happy bit, the relevant function was provided by the happy bit? That's the change. Isn't it?
Well, its proposed message is not the same. That's the Samsung proposed EDCHSI-like message. And then he says in that sending the message serves as the mechanism for asking. So it's the sending of the message that is the mechanism for asking for resources. And so it's the fact that the messages have been sent that's the request for resources. Although that could be done by a signal within the message, although an alternative could be to have a bit inside the message that says, effectively, this is a scheduling request, or I don't want any more data, which is the sort of the middle option that paragraph 37 refers to, that then isn't the claim. So given that last clause makes it clear that the judge is not talking about a bit in the message that indicates that it's a scheduling request. The only thing that can indicate that it's a scheduling request is being made is the fact that the message has been sent. So it's the presence of the message turning up at the receiver says, I want some uplink resources. And if you look inside the envelope, you can see how much data I've got and what the priority of it is.
I mean, we are parsing this sentence quite a bit, but in the judgment, and the judge says that that option B indicates that its proposed message is not the same. One of the things it's not the same as is, if you look back 2 sentences, that it's an 18-bit message without a bit identifying that it's a scheduling request.
Yes.
But by saying it's not the same as that, one might incautiously think that that means it's not the same as an 18-bit message without a bit identifying it as a scheduling request. And the only way to be different from that is to be an 18-bit message with a bit identifying it as a scheduling request, which is what, as the judge then points out, that could be done.
Yes, but the fact that that could be done means that before he gets to that last clause, he's not envisaging that that's happening.
Okay.
Because he says it's the sending of the message that asks for resources, although that could be done by adding the bit in the message.
Right. Or maybe it could be done means because he's making the point that it can be done. But yes, I think I understand how you're reading it. I'm just not sure myself that it's the only way of reading that paragraph. But that's true of almost every utterance in the English language. As I understand it, Mr. Hitchley, your point is, if you read 167, the judge has found that Samsung teaches the idea of using the 18-bit and only 18-bit message itself as a scheduling request, where its presence is the indication that scheduling is being asked for.
Yes. Yeah. I mean, of course, my lord, what we go back to Samsung, and that is what it says. So if we go back to tab 1 of the supplemental bundle, sorry, yes, the original supplemental bundle. Yeah. It's page 2. In the middle, B, sending an EDCH SI-like message on a non-contention resource, which is provided periodically, i.e. use the non-contention scheduling request channel.
I mean, that doesn't say anything about what you're using as a, I mean, because it's an like message, it would be a like message if it had a code at the beginning to say this is a scheduling request.
Yes, it could have been, but then we go back to
you were suggesting that it positively states in Samsung that that's what you should do. I'm putting to you that doesn't positively state in Samsung.
But of course, this, as I explained at the beginning of this argument, this argument arose from Dr. Moss's evidence that the only thing the skilled person would do would use the same 18 bits as were in HSUPA, and that's why it came in the reply evidence. It was sort of, okay, well, if that's what you say, you take that message and you send it on this non-contention channel that Samsung proposes. It has to be the presence of that message that tells you a scheduling request is being made, because there are no bits anywhere in it that you have to decode to go, is this a scheduling request or not? Because it's the fact that messages have been arrived with the extra detail about this is how much I've got, this is how important it is, contained within it, that indicates a request is being made. As we say, that's precisely the same option as in paragraph 37 of the patent. So, that was obviously that finding, as the judge came to, was when he was discussing the primary case. We need to look at what he said when he dealt with the secondary case in 172 onwards. And in 172, he set out summarised the arguments. And as we see in 172, 4 lines up, he noted that Professor Valenti pointed to paragraph 37 of the patent, which contemplates this. So in 173, the first point he says is the skilled person wouldn't have seen paragraph 37. Of course, that's right. And the argument wasn't that the skilled person would get anything from that. All Professor Valenti was doing by referring to that was identifying what the target for obviousness was. He then says, Professor Valenti accepted that in an HSUPA system, the base station understood there was a request for uplink resources, not from the presence of the signal, but from the contents of the signal. Now that's a reference to the fact that in HSUPA, the scheduling information was sent at the MAC layer, so it all had to be decoded. And then there's a little extract of Professor Valenti's cross-examination, which the judge has not quite quoted it accurately. So I'd just like to show you what the professor actually said. So could we go to the additional supplemental bundle at tab 12? And it's page 121G.
Sorry, we're in the amended one.
The amended one. I'm sorry, my lady. I'll get it right by the very end. So 121G, and at 760, line 16, the question was asked, so you're proposing a system where the base station works in a different way to HSUPA, and Professor Valenti said that's not his proposal, it's Samsung's proposal, and then carries on. And then if perhaps you could just read the question and answer at the top of 761, because that, as far as best we can tell, is what the judge was quoting from in the judgment. And so what the judge actually, I mean, what he left out of the quoting judgment was the sentences at line 11 and 12. This is LTE. Of course, it would be different. And whilst that's perhaps not, it does lose some of the emphasis of what the professor was saying. Is that he was making the point that although the message in HSUPA was sent at the MAC layer and therefore had to be interpreted, and although Samsung was using the expression EDCH-SI-like message, after all, it was going to be a message that was sent in a different system in LTE, and so it was always going to be a different system.
I'm not understanding the point you're making. As I understand it, you agree that it's right, but before the quote, the bit in the judgment at 173 up until the quote starts, you agree that's correct?
In HSUPA, that's what happened, yes.
In cross-examination, the professor accepted that in HSUPA, the base station understood that there was a request for uplink resource, not from the presence of the signal, but from the contents, and you said that was to do with the fact it was on the MAC layer.
Yes, that's right.
And then the point you're making is that the quote misses out and does, as you're obviously quite right, it appears to miss out a couple of sentences without even having a little ellipsis. Well, I'm sure we've all done that, but I take the point. It is there. And the significance of the missing words is
well, it loses some of the emphasis that what the professor was saying was, well, this is a different system, so it wasn't going to be identical. And because the judge seemed to be quoting this bit of evidence as saying, well, there would have to be a change, and there would have to be a change because this was a different system.
right.
And of course, it was going to be on a different channel as well, because this is Samsung's non-contention channel, not the data channel as the message was sent in HSUPA. So then if we go back to the judgment, and the judge says, in the next sentence, the EDCH message contains scheduling information, but not a bit identifying it. Yes, that's correct. And that function in HSUPA was this happy bit. And then he says Lenovo.
Is that complete, that sentence? Because isn't the point you've just explained to me that in the 173 that the base station also understands that there's a request from the content of the signal, but it just doesn't need to have a special bit in it, because it doesn't need that, because it's being sent to the MAC layer. It's decoded in that way.
It has to, in HSUPA, the SI message has to be decoded to be understood because it's in the MAC layer. It's not the fact that the presence of it can't be detected, because it all has to be decoded because it's at a higher layer.
Right.
But
my point is that is it as simple as saying that the function of identifying the message as a scheduling request is carried out by the happy bit? That's not really what the happy bit does, because the message itself identifies itself because of its inherent properties as a scheduling request. But in order to find that out, you have to decode it.
Yes, I think it.
But isn't that what that paragraph 173 is saying? Which I thought you agreed with.
In HSUPA, the message had to be decoded to work out the contents of it, and to understand whether there was what amount of data the UE had in its buffer. The reason why I'm pausing, my lord, because it is possible that in HSUPA the message could say I've got no data. It wasn't being sent. It was sent periodically and wasn't being sent. I don't think anything turns on that, but that.
As I read that second sentence of 173, what's going on there is the judge is saying that in the USPA system, the base station can understand that 18-bit message as a request for uplink resource from the contents of that signal itself.
Yes, in HSUPA, that's what happened.
Yeah. So it isn't actually complete to say that in the next paragraph, it's true, as the judge said, there isn't a bit in the 18-bit message which identifies the 18-bit message as a scheduling request, But that's because that has already happened for the reason explained in 173.
I'm not sure I'm following your lordship. The scheduling information has to be decoded to see what the contents of it is, and if there is information in that tells the base station that there is data in the UE's buffer, then that will be having worked that out. That will be interpreted as a request for uplink resources.
Right. So it's not the my point. All I'm trying to point out is that you've just described isn't using the happy bit as a scheduling request. It's using
the happy bit is another way of sending a scheduling request.
Exactly.
They're both. They're two ways of sending scheduling requests in HSUPA. So the judge then goes on to say that our secondary argument requires the skilled person to have believed that the EDCHSI-like message in option B should be changed from the message which he or she would have been familiar. But the argument doesn't require the message to be changed. It's the same message with the same bits of same information in it to be sent. The only difference is that it's being sent as Samsung teachers on Samsung's NCSI physical channel. That's the difference. So the only difference between what the skilled person knew about the EDCHSI-like message in HSUPA and sending that message in Samsung is that you send it on Samsung's channel.
But what I think the judge, as I read the judgment, what the judge is doing here is saying that in the HSUPA system, the communication of a request for resources was communicated either by the happy bit, but let's forget about that, or by the contents of the message. That's what 173 is talking about, and he comes back to it in 174. Now, Samsung doesn't say anything at that level of generality, at that level of specificity about how you do that. It just simply says use an HSUPA-like message. And the point the judge is making, as I read it, is HSUPA-like messages indicated that there was a scheduling request by their contents. Therefore, what Samsung will be understood to be suggesting is to use a message which indicates that it's a scheduling request by its contents. Now, your case argument is that you say that it would be obvious from that to just use the message on its own without changing anything at some level. I get that. But the point the judge is finding against you is that even if you did that, you're still, if you're following Samsung without adding something extra, you're sending a message which is to be identified as a scheduling request by its contents. But to be within the claim, you have to send a scheduling request which is not identified as a scheduling request by its contents. It's identified as one by its presence.
When the pattern talks about the option of adding those extra bits in, it's the sending of that message, it's the arrival of that message that indicates a scheduling request is being made.
Yes, but the para 37 of the patent is all about a situation in which the presence of the message is the indicator that there's a scheduling request. You can have content as well, but what indicates the request is its presence. And what the judge is pointing against you is that Samsung doesn't take that extra step of saying that you could use the presence alone of the message, even if it's an 18-bit message. You're not using its presence as an indicator, you're using its contents. And that's why the word contents is in 173 and 174.
But when the only thing that's being sent on the non-contention channel is the 18 bits, which just one more point to add into that is that I might better show my this little bit of.
Well, I'm just reading the judgment.
Yeah, but it was common ground. So Dr. Moss agreed that the logical way of implementing Samsung would be that you only sent the 18-bit message or the message when you wanted resources, and you didn't send it when you didn't want it.
Okay.
Fairly straightforward and uncontentious. And when you're sending that kind of 18-bit message on the non-contention channel when you want resources and not sending it when you don't, then it is the fact that you are sending the message that means that the scheduling request is being made.
Well, it's not, because you're always talking about transmission, and I'm talking about reception. If you're the receiver, you don't necessarily choose to take. You don't necessarily use the presence, the mere presence of a message, whether you've decoded it or not, as an indicator of anything. That's a matter of design. Well, you could call it design choice. I'll call it that, design choice by the person's designing the receiver. It's a different kind of receiver, whether it's identifying the presence of the message as an indicator and then decoding it and predicting the contents, or only ever decoding the message and working out from the decoded information whether there's a request or not.
But again, I mean, I've also seen the judge's findings in relation to primary case that the skilled person would have always wanted to have had that information. So, on those findings, the skilled person is always going to want to decode the message to find out the details of how much information there are. And when you're doing that, the fact that the message is there tells you the scheduling request is being made, because there's nothing else to tell you that this is a scheduling request, because there isn't the bit in it indicating it's a scheduling request.
Oh, but the judge's finding is about contents. That's what he says.
Sorry, which sentence are you looking at?
I'm looking at the
Last
bits of 174.
But when you're sending a message that doesn't have any contents in it that say, I am a scheduling request, then it follows that the only way that the information or contents of I am making a scheduling request is transmitted from the sender and understood by the receiver is when the receiver receives that message. It knows from the fact that it's received it that scheduling request is being made.
That's one without the 18 bits in it.
That's one without one without a bit in it saying I am a scheduling request, because the only thing that says I'm a scheduling request would be a bit in it saying this is scheduling. Saying I've got X amount of data in my buffer isn't saying this is a scheduling request. It's a providing of information about how much there is to send. So the only thing that tells the base station, the only thing that the base station can rely upon to know that the scheduling request is being made is because it has received that information. And it's the reception of the information that tells it that there's a scheduling request being made. The rest of it is just information about how much data the UE wants.
That's not how as I understand it, the point the judge is making is that's not how US HSUPA worked in the first place. It's just not how it worked.
No.
And that's why he's finding in 174 to say it wasn't obvious that you would change the way. He's recognising that HSUPA and LTA are different, but he's not accepting that it was obvious to change the method of working to do it the way you're saying in LTE.
Well, that
so it wasn't how it was done.
No, but that follows from the fact that it's a different channel.
Right. Well, maybe no doubt it does, but that's not the point, is it? I mean, what I'm trying to understand, because as I understand your point, is that what you're setting the argument up for is to say that there's an inconsistency in this paragraph, with this section, with the finding in the previous things, and that's the bit I'm not understanding, because it seems at the moment the judge's conclusions there are not inconsistent at all. Why is it inconsistent?
Because in 167, the judge finds that it's the sending of the message that serves as the mechanism for asking for applicant resources, and not the fact that there's any particular content in the message. This is that last clause, although that could be done by a signal within the message. So it's the sending of the message. And because there's nothing in the message that indicates that it's a scheduling request, the only thing that the receiving entity, the base station, can act on and can rely upon to know that there's a scheduling request is the fact that that message has been received at the relevant time. Because
now I've understood this. That's not right, is it? Because in HSUPA, the sending of the message serves as the mechanism from the phone's point of view of asking the question, but it doesn't serve as the mechanism from the receiver's point of view of deciding whether it's been asked because of the way HSUPA works. It has to open up and has to examine the contents in order to work out whether it's a scheduling request because of this MAC layer business. So that's a very specific feature of the way HSUPA works. Now, the point you're making, I do understand, is LTE works because of the way the LTE system works. It works in a different way, so that it's true that you could, if you sent 18 bits on this non-contentious channel, the receiver could treat the presence of the 18 bits as being a scheduling request per se, but in doing that, it would be acting in a different way from the way HSUPA worked.
Oh, absolutely.
And nothing in Samsung tells you to do that. If you were following from Samsung, you would, and this is why the judge talks about contents, why wouldn't you do it that way? It's the could and would thing again.
Because there's, I may be getting to the stage of repeating myself, because there's nothing in the 18-bit message that tells the base station that this is a scheduling request. What tells it is a scheduling request is the fact that something has been received by the base station on that channel from the UE, because that's what it's sending on that channel. So it's not that it has to decode anything, which is the middle option in paragraph 37 of the patent, to work out is there a 0 or a 1 to say whether it's a scheduling request. It is the fact that it receives a message on that channel, tells it there's a scheduling request, tells it the scheduling request is being made, and it then has to look inside the request for more details about how much data there is to send. Mm-hmm. And that's an option that the patent plainly covers, the judge's finding, and we say that's exactly what using the 18 bits on Samsung's channel would have done, because it would have. There is no other way of the base station determining that it's a scheduling request other than the fact that it receives the message.
Okay.
And then just to pick up the last, just in 174 again, the judge says, it's 175. The second option still requires the school person to have focused on the uplink message of option B, section 3.2. Just pausing there on that one, and we say it doesn't have to focus on that because it was common ground that was the only way that the UE without resources would get resources. So that was something that the skilled person was going to have to address in any event. And then the last one, to have considered OOK as a substitute. You may have been around this loop already. Is that we say that if you were told that it's sending that 18 bits on Samsung's channel without a signal in it saying I am a scheduling request, that is implicitly a message that's interpreted by its presence as a scheduling request, because there is nothing else to tell the base station that this is a scheduling request.
Yeah.
Now, just before I sit down, can I just deal with just very briefly just a couple of the points put against this point? The first one, actually, can we get my learned friend's skeleton out? That's core bundle tab 4. And go in that to 92. Near the end. And if we look at paragraph 92 in the second bullet, it says at 128 the judge records that all integers of claims 1 and 14 were disclosed apart from integer D. As I've mentioned several times along the way, that isn't the case. It was common ground that there was, for example, integer 1G was missing from Samsung, but that would have been obvious. And the judge in 128 also did say all was obvious. And then if we go over to 95, my friends seek to say a point in the middle of that paragraph that the issue of novelty was not open to the judge or even argued, so he can't have been made in the finding set out in 73. The proposition that seems to be being put is that the effect of the secondary argument means I'm effectively arguing a novelty case, and that wasn't pleaded. Mm-hmm. But I'm not arguing a novelty case, my lord, because I think it was integer 1c and integer 1d were missing and agreed to be obvious. So it was always an obviousness case. It's just that the secondary case dealt with the issue of integer 1d. And then, just to deal with the point in 94, he says, the reason the judge used the expression, although it could be done by, is because he was rejecting the suggestion by Lenovo that Samsung's EDCH message would, by analogy with the EDCH message, lack a bit. Now, the judge didn't reject the argument that Samsung's message would lack a bit containing HSUPA, because it was never suggested by InterDigital that the obvious thing to do in the light of Samsung would be to add in an extra bit into the 18 bits so that there was a 19-bit message, one of which was, I am a scheduling request. That was not suggested by Dr. Moss, and you can tell that from the fact that all the debates we've been having has been between 18 bits and 1 bit. Nobody ever said 19 bits. So I mean, we'll see whether my friend can show you where it was suggested that the obvious thing to do with the Samsung message would be to add an extra bit into it. That simply was a case that wasn't ever made. It was always you would take the 18 bits and you would use them.
Isn't the point that in that respect, you've got the 18-bit message. In order to decide to take them and use them without an extra bit, a new 19th bit, you have to have thought of using OOK as the way of signalling that it's a scheduling request. Otherwise, you would say, well, I haven't told that it's a scheduling request, so I better put in a bit that says that.
Well,
because as I understand your secondary case, at least I think I've understood, you're trying to put it on the basis that the skilled person doesn't have to think of OOK. They just do something, and it comes for free, effectively.
yes, and I mean, the reason for that is this is a resource that has been, a particular time, frequency and code has been reserved for the UEs to make scheduling requests. So although you wouldn't need an extra bit saying I am a scheduling request, because the resource that's been reserved to each of the UEs that appears periodically has been a resource for sending scheduling requests. So there wouldn't be a need to do that. So
is that common ground that the non-contentious channel resource is only used for making scheduling requests?
Well, certainly Samsung. That's what Samsung is only talking about. Now, of course, you could have a channel where there are periods where they send other control information as well as the scheduling request. But Samsung is clearly envisaging at least part of that resource as being for sending scheduling requests.
Sure, but you could be sending scheduling requests which contain within them a bit that indicates they're scheduling requests, which you might well want to do if there are lots of other requests coming on this channel. I don't know, did the evidence go into any of that?
Well, we got into whether it would be obvious to send HARC along with scheduling requests in relation to Claim 9, but Claim 9 doesn't add anything over Claim 1. But that would have been a different. The evidence was that the school person, the way that would have been done, is they would have set aside a different code resource for the HARC feedback to the scheduling request feedback. So the base station will be able to tell this is the resource that I've given each UE for scheduling requests. And although I'm also getting other stuff coming up from the UEs, that's on a different code resource, and I can tell what those are. I think I've summarised that fairly. That was one of the things they found. But there was. Oh, and I now can't remember why we've gone down this rabbit hole. Have I answered the question that you put?
I'm sure you have. I've got a happy bit.
I lost my note unless I can assist you any further.
Yes.
My lords, my lady, I'm going to start with some relatively basic points of patent law before going into the detail of Lennon Friend's argument, set out a number of propositions and then make them good. As my lords, my lady will appreciate, a number of points taken below. The only one before this course is obviousness of Samsung. And I'm going to make three submissions, which I'll then make good. First, obviousness is a single and relatively simple question of fact. Obviousness is a hard argument to win on appeal because it's a jury question. My learned friend has to identify a point of principle in respect of which the judge erred in order to get his appeal off the ground. Now, my Lord Justice Birss will be familiar with these propositions. My Lord Justice Warby, Lady just thought maybe somewhat less familiar. I'm going to show the first case cited in our skeleton argument, which is Unwired Planet at Authorities tab 4. And the facts don't matter. I can go straight to the sidelined portions. I'm not going to read them out. I'm going to try and highlight some points. That begins on Authorities tab 4 at page 74, paragraph 100. And I will invite my lords, my lady to read this, but I'll try and summarise the key points. Paragraph 100 sets the scene. The question of obviousness must be considered on the facts of each case, and a number of factors are there identified. I particularly rely on paragraph 101, which is the quotation from this court's decision in Medimune and Novartis, which is that the task of the court is ultimately to evaluate all the relevant circumstances in order to answer a single and relatively simple question of fact. Was it obvious to the skilled but unimaginative addressee to make a product or carry out a process falling within this claim? And in this case, the question is, was it obvious to the skilled but unimaginative addressee reading Samsung to make a product or carry out a process falling within the claim? The question is not, was it obvious to the patentee himself or herself? Patentees tend to be inventive people. The question is not, is it logical once someone's told you the answer? That's not the question. The question is always the single and relatively simple question of fact set out here. Moving on to the next paragraph, Lord Justice Kitchen explains that it's the nature of this multifactorial evaluation of evidence against a single statutory test which underpins the reluctance of an appeal court to interfere with the trial judge's decision on an issue of obviousness unless he has erred in principle. And I would submit the present as one such case. And I don't need to read out the whole of that extract from a very famous case of Biogen and Medeva, just the last few lines, where the application of a legal standard such as negligence or obviousness involves no question of principle, but is simply a matter of degree, an appellate court should be very cautious in differing from the judge's evaluation. And the reasons for that very cautious approach are explained in paragraph 103 by Lord Justice Lewis in the Fage UK and Chobani case. A number of reasons are set out. The one most often cited here is number 2, trial is not a dress rehearsal. It's the first and last night of the show. But going on, Lord Justice Lewison points out that duplication of the trial judge's role in appeals is a disproportionate use of limited resources. And the next point is one I would particularly stress. In making his decisions, the trial judge will have regard to the whole of the sea of evidence presented to him, where an appellate court will only be island hopping. And I do criticise my learned friend for engaging in island hopping in this case, particularly on findings he's inviting this court to make for the first time about on-off keying. And finally, by way of balance, obviousness is not an appeal-free zone. That's the point made in paragraph 104. And then there's a quote from Lord Justice Jacob and Teva, UK and Leo,
For an appeal to succeed, an appellant must identify at least one point of principle in respect of which the judge erred. If that can be done, then the question is open to independent evaluation by this court. Now, my lords may have noted, my learned friend didn't mention it, that the trial judge actually refused permission to appeal. An application was made to this court, and Lord Justice Arnold did grant permission, but he referred to the uphill task, which my learned friend has, and my lords have probably seen that, but it's in Core Bundle tab 8. Although Lenovo face an uphill task in demonstrating the judge erred in principle in his assessment of obviousness, and then the judge gives permission anyway. And my learned friend's arguments to my lords and my lady today have been the same arguments in relation to which Lord Justice Arnold used the phrase uphill task. Now, because it's important to identify a point of principle, I'm going to go to my learned friend's grounds of appeal to see what we see there in terms of a point of principle, because if they're merely complaints about the result, then such complaints can only come into play once my learned friend establishes that. Now, the grounds of appeal themselves are also in the Core Bundle at tab 1, pages 14 to 15. Now, my lords and my lady will have seen this. My submission is that point 1a, in the primary case, is the only one which is even arguably a point of principle. And that goes to the any stated advantage. But my lords and my lady will remember my learned friend's acceptance in his oral submissions that there's an actual advantage, and he even took you to some passages of evidence about the actual advantage. So it's the point about the stated advantage, which is said to be the point of principle there. B is a complaint about a holding. There's no point of principle there. C is the plot solely point that my learned friend does rely. And my short answer to that is it's simply not engaged in this appeal at all, for reasons explained to the judge, explained by the judge in his judgment. I'll show my lords and my lady in just a moment. But the way it's put here is that by failing to identify on his factual findings, on-off keying was an old idea not thought to be of practical utility in cellular networks. But this could not be relied on in support of inventiveness because the patent did not show it to be practical, contrary to the prejudice. So we're looking for factual findings about the idea being, quotes, not thought to be of practical utility, close quotes, or some sort of prejudice. And we say that simply doesn't get off the ground for all sorts of reasons. But one of the points, which my Lord Justice Birss pointed out, is that on-off keying isn't in the claim anyway. The only reason we had on-off keying, and also 18-bit versus 1-bit, was because that was the route they constructed by which they could attack obviousness, not because there's anything in the claim about 18 bits or 1-bit, and there's nothing in the claim about on-off keying either. So it was an artifact of the way the case was argued. But I will submit, I will demonstrate to my lords and my lady that paragraph 1c, and indeed my learned friend's oral submissions, are not an accurate statement of the findings which the judge actually made. But at least in the grounds of appeal, my learned friend is expressly relying on the judge's factual findings and is not inviting any fresh findings. He says failing to identify on his factual findings. So why then does my learned friend spend so much talking about primary evidence and on-off keying? As I say, that was part of his route. But we do suggest in our skeleton argument, I repeat now, that my learned friend must lose unless he overturns the judge's findings on on-off keying. That's why he's spending so much time on it. Now I will take, and 1D, I should say, that's a complaint about a finding, that's not a point of principle. And 1E is gone entirely, so we can cross that out. When we get to the secondary case and obviousness, I'll explain in detail, but our submission is it's a simple misunderstanding of what the judge said. If Malone and Friend was right, then Malone and Friend would have won on the primary case. The judge would have produced a completely different judgment about what was an issue. Malone and Friend would have won. And he gets all that out of half a sentence in paragraph 167 from a 298-page judgment. So that's all I propose to say about the grounds. What's the high-level answer to Malone and Friend's appeal? Well, we will be going through the judgment. My lords and my lady have done that already, I appreciate it, and they've been taken through it. I'm just going to summarise some of the key points and then develop these points later. One is the judge's construction of the key integer, which is 1D, according to the Great Law. I think we've touched on this, but without actually quite reading it. It's paragraph 100 in Core tab 7, page 94. And this is where the judge sets out what his construction, his interpretation of integer 1D is. And he records our submission as being that the transmission burst of claim 1 must be interpreted as a scheduling request. It is not enough if the EMB could interpret the presence of the burst in that way. I agree. And that wasn't disputed. Malone Friend took you to it and said it wasn't disputed. But that's why we see the word could appearing elsewhere in the judgment. It's not enough, in other words. And para 102, it doesn't exclude the possibility that the transmission burst may contain information to be decoded, as well as the burst of itself being indicative of a scheduling request. None of that is disputed. That sets the background. Now, my friend did go through the judgment on Samsung. I will do the same. But I'm doing so briefly at the moment. If I can invite my lords to pick it up at, in fact, 123 on page 98. As I've said, Samsung was only relied on for an inventive step. And then the judge sets out at 124 to 128 the disclosure of Samsung. And then at 128, the judge says the issue inventive step over Samsung was whether it was obvious to implement this option, namely option B, so that the presence of the message on the NCB channel was of itself indicative of a request for uplink transmission resources. The experts were agreed that all the other integers of claims 1 and 14 were either disclosed by Samsung or were obvious variations of what was disclosed. Malone Friend is right then to say it wasn't anticipation of Samsung as a whole, but I can correctly say, having been corrected by Malone Friend, that the issue is obviousness of integer 1D. And that's what the whole judgment is about. And that is what sets the framework of what the actual dispute was. And then in paragraphs 129 to 130, I think a point that may be familiar to my lord and my lady by now is that, well, HS UPA was a well-known prior system, and the reference in Samsung to an EDCH SI-like message would be understood as being a message which was similar to the EDCH SI message from HS UPA. It was like it, but it was to be used as an LTE network rather than HS UPA. And the whole significance of this, and I think I'm treading all ground here, is the point in para 130 that in HS UPA, that message, the 18-bit message, had to be interpreted, it had to be decoded. They didn't just detect the presence of the signal, and that's the point that's made here. So thus far, the experts are agreeing as to how HS UPA worked, and they're accepting that this message 18-bit had to be decoded. Now, Malone Friend does subject Samsung to, at least in some places of his argument, quite a close textual analysis, but as the judge said in 137, the document can't bear the weight of close textual analysis. In any event, Malone Friend's task is try and come up with some reason as to why it would be obvious to the skilled but unimaginative addressee reading Samsung to make a product or carry out a process falling within the claim, because that's the single question that has to be answered. And my friend's problem is the judge considered exactly that question in paragraphs 165 to 171. And as my lord and my lady have heard earlier, the reason for rejecting it was that Lenovo's argument involves the very real danger of applying hindsight. That's the point about on-off keying had been far from the forefront of the skilled person's mind as an option for an uplink channel in LTE. And it's important to remember that Friend's case involves modifying Samsung so as to introduce this idea, even though it's not taught or even hinted at Samsung. Friend didn't spend any time trying to suggest, oh, Samsung teaches on-off keying, it hints at it, it gives a clue. None of these things were given. Not for a sentence, not for a single word. So my submission is that the judge has asked himself the jury question, has given his answer. Lenovo's case involves the very real danger of applying hindsight. And respectfully, that's the beginning and the end of the appeal. It would have been also different, of course, if there had been anything in Samsung which pointed towards modifying it so as to arrive at the claimed invention. But it's not suggested there was. Now, we heard quite a lot about the Pozzoli point. I will spend a bit of time on that. But I was quite struck by the fact that the judge actually answered that in paragraph 147 in terms we would respectfully adopt. In paragraph 147 of the judgment on page 102, the judge explains, I do not think this case is analogous to Pozzoli in that way. I did not understand InterDigital's argument to be based on removing a technical prejudice against a known or obvious idea. InterDigital's case was that the invention of the patent was new at the priority date. The invention was neither present nor obvious in the mind of the skilled person. There is debate about reasons why the skilled person would have been driven towards or away from the invention. The cogency or otherwise of these reasons in both directions must be considered carefully. But that applies to any assessment of obviousness in a patent case. So what the judge says here is, our case was never about removing a technical prejudice. And nothing in Milan and Friends' grounds of appeal, or indeed his skeleton argument, even mentions this paragraph, which we respectfully say is a complete answer. It's just not this case. Now, these are my key reasons why I say this appeal must fail, but I have just one or two more submissions as to why we say it must fail, so I shall go on to those. And the first topic I would like to start with is paragraph 71 of the judgment, which is the judge's findings about on-off keying. And we saw that in my learned friend's grounds of appeal, he sought to equate these findings with a prejudice. And in his oral submissions, he did mention prejudice, but he often used the phrase, quotes, not thought to be of practical utility in cellular networks. And my submission is there's just no such finding made by the judge in this paragraph, or indeed anywhere else. If we just take it down, I'm going to say it's not open to my learned friend to challenge these, but in any event, they are plainly correct and plainly supported by the material referred to by the judge. I find that on-off keying was known to the skilled person at the priority date, a basic technique taught at university. Well, that's not in dispute. That's not a prejudice. Its utility depended on issues of noise, cost, and energy consumption. Again, that's not a prejudice or an idea that it's a suggestion the technique is not thought to be of practical utility. It's just saying, well, it depended on this, this, and this. And again, that's not disputed as such. On-off keying would have been viewed as having no application as a means of transmitting data and was very seldom used in transmitting control information. And I don't believe that's disputed either, particularly the very seldom used in transmitting control information. And finally, the skilled person at the priority date would not have been aware of any use of on-off keying in a cellular network implemented up to that date. Now, I'll cover that because my learned friend has a point on the textbook. But there's no finding anywhere here, as my Lady Justice Falk pointed out, of any anything about on-off keying was not thought to be of practical utility in cellular networks. Just that it wasn't used, or rather was very seldom used in transmitting control information. And these findings were not merely properly open to the judge, but in my submission were plainly correct. Now the judge goes through a number of points leading up to this in the sections going up to it. But before we go into para 62 in any more detail, because I don't have a detailed point about that, this is the reference in the HSDPA, HSUP for UMTS book. The fact that this method of combining BPSK with on-off keying appeared in the textbook is inconsistent with any idea or any suggestion that on-off keying was, quotes, not thought to be of practical utility, close quotes. It's not thought to be of practical utility. Why is it in the book? Why is there no help for it? And similarly, the fact that on-off keying was used in a system called CDMA 2000, which is referred to elsewhere, is inconsistent with there being a prejudice in the field because there wouldn't have been that use either. And if it's actually used, why is there said to be any widely held belief that it's not thought to be of practical utility in cellular networks? The problem with that argument is CDMA 2000 was a US system which wasn't common general knowledge here. So it was a bad example for purpose of common general knowledge, but it was actually an example of it being used. And finally, in paragraph 71, if you go back there, the point about the judge would not have been aware of any use of on-off keying in cellular network implemented up to that date. That's not an example of prejudice either. It's just a finding of fact. Now, let's explore some of the points made in these previous paragraphs in a little bit more detail. What were the examples of being used that Professor Valenti and Lenovo put forward to suggest it was anything other than at the back of the skilled addressee's mind? Well, in paragraph 68, we see Professor Valenti's example was a TV remote, which he quoted from a textbook. And as the judge says, it seems that this was a rare example in context not close to cellular networks. And then we also see that Professor Valenti, in paragraph 69, asked Lenovo's lawyers to conduct a search to find examples of on-off keying being used for any purpose in cellular networks before the priority date. So, emphasize the words "for any purpose in cellular networks." And they found just one example in a paper which Professor Valenti properly conceded would not have formed part of the common general knowledge. This is the CDMA example in which on-off keying was used in a downlink paging channel, not as an uplink.
Sorry, is this supposed to be the same as what the book covers?
No, it's not.
It's not.
It's a different. There's two examples.
They're both downlink.
Yes, the book is yes, the book's certainly downlink, but I'll be submitting there's no evidence the book is common general knowledge.
I see.
If you look at the reason,
I understand what you're going to say.
Yes, if you look at the reason it was deployed, it wasn't for this purpose. But the other example is also downlink, but it's in a different network entirely, which is CDMA 2000.
Okay, I think I was confused because you referred to CDMA 2000 earlier, but it's only relevant to the
only one
69.
Yes, para 69 CDMA 2000. Now, there was a suggestion that paragraph 71 is inconsistent with the rest of the judgment. I'm learning from spent some time on that this afternoon. And my learned friend relied quite heavily on the book, the Holman Toscala book referred to at paragraph 62. Now, my overriding objection to this is that whilst my learned friend's appeal is framed as a submission based on the judge's own findings, this is an example of island hopping, where he seeks to rely on a partial account of the evidence. I'll say why it's partial in a moment, but I'll follow my learned friend down this avenue to show why I say it's a partial account of the evidence. If my lords and my lady could go back to Paris 58 and 59, as my learned friend said, I think my lords and lady appreciate, there was actually two disputes between the experts, and one was about terminology, and the other was how broadly it could be defined. Now, the point about terminology only came in because some forms of on-off keying might fall within the claim and some might not. And the way you test that is you apply the language of the claim. Are they actually using the presence of the transmission burst as indicating a request for resources or not? That's how. So why use the term on-off keying, which is not in the claim? Because it sets up a puzzle which you then have to solve as well. Is this within the claim or not? But anyway, be that as it may, there was a dispute about, well, what did the term mean? And that's why the judge approaches it in this way. First of all, let's decide what it means. And secondly, let's decide what's common general knowledge. Now, in deciding the question of terminology, which he's doing in the first part of this passage, the judge does rely on the Holman Toscala book at 62, which he described as offering independent support for Professor Gallante's view. So the only purpose of that book at this stage of the judgment was the terminology. It's not as if the evidence established the existence of a dictionary definition somewhere, because then the judge would have gone to the dictionary definition and used that instead. And the mere appearance in this book doesn't of itself establish that anything was common general knowledge. I'll go to the evidence in a minute, but just as a proposition, an illustration of that in the present case is about CDMA 2000, because this book, as pointed out by Dr. Moss in his fourth report, had a chapter on CDMA 2000, but the existence of that chapter didn't reflect the common general knowledge. It was just if you wanted to find out about CDMA 2000, you could go to that chapter. And we see that in paragraph 64, which is the same passage dealing with terminology, the judge relies on two other documents. One's a proposal from Qualcomm Europe, which is referred to halfway down the paragraph, and the other is from Motorola, 4 lines up from the bottom. And the only use of these two documents at this stage was also terminology. It wasn't suggested that the Qualcomm or Motorola documents were themselves common general knowledge, but that wasn't the purpose for which the judge considered them at this stage, because he's just testing what the meaning of the term was. Now, my lord and my lady might not have appreciated this, but although Professor Valenti did exhibit this chapter, being the chapter which contains section 535, it runs to about 35 pages long. He exhibited the chapter. He never in any of his reports said that these pages, in other words section 535, showed an example of the use of on-off keying. And he could not explain to me why he did not. He actually exhibited this chapter for a different purpose, which was to provide a description of the operation of HSUPA scheduling. And I can show my lords the evidence about that by going to supplemental bundle, page 5. Sorry, tab 5, page 58. Now, this was his second report, in his first report, 70 pages long, he had 15 lines on the obviousness case, which is now being advanced. We see that by the time of the second report, it's sprouted to about 3.5 pages. There's much more detail.
Oh, which paragraph?
I'm on page 58, it's paragraph 94. So we say that this is the section where he's dealing with integer 1D. And in para 94, he says HS-UPA scheduling is described in chapter 5 of the book, HS-DPA, HS-UPA for UMTS by Holman Tosca, which I exhibit to this report as exhibit MCV 10. This book was published in 2006, and its description of the operation of HS-UPA scheduling illustrates what would have been common general knowledge to the skilled person at the priority date. So it's been put forward as a description of the operation of HS-UPA scheduling. And in particular, he refers to section 556, which explains that Node B makes use of 3 pieces of information, happy bit, SI, and currently used data rate, and makes various comments relating to section 556. And when we look at 556, we see that this evidence is correct, but there's nothing in it about on-off keying. And the particular passage he's mentioning, section 556, is later on in the supplemental bundle, tab 7, page 93. And I'm not going to read the entirety of this section 556 out. But I will submit that, just as promised, it does deal with HS-UPA scheduling. That's the top of the section. It does explain about the happy bit and the SI in the second paragraph down. For instance, it says in that paragraph, HS-UPA scheduling is facilitated using 3 physical channels, EAGCH and ERGCH, in the downlink, and a happy bit carrying EDP-CCH in the uplink. In addition to this, the EDP-DCH delivers an SI message in the MAC-E header. For additional details for the Node B scheduler, SI can be used in the Node B scheduler in addition to the happy bit received in the EDP-CCH. One of the problems of this type of case is the sheer number of acronyms. But if I can just simplify this, it was being relied on by Professor Valenti as explaining how HS-UPA scheduling worked. It was relied on as explaining what the SI message was and what the happy bit was. And that's probably as most we need to get. As my learned friend pointed out, the happy bit is it's actually 1 bit among 10. It's sent in a 10-bit string, which are also coded, and the SI is the 18 bits, which is something else. These are 2 different things in HS-UPA, and they each have to be decoded to get the contents. They don't just detect the presence. Anyway, we've got some valuable information about the SI message and the happy bit. And if one turns over the page 94, it certainly is a bit more about happy bit, SI, and data rates. There's nothing at all in here about on-off keying. So the only purpose for which Professor Valenti cited this in his second report, which is a much more detailed account, was for the proposition in this para 94, not to say, look at section 535. Now, there was some cross-examination on that, which I will show my lords. And it's in same bundle, supplementary bundle, tab 11, page 118. Page 574, line 8 of the original. And I ask Professor Valenti, you explained to my lord on Friday and again today, it's between your second and third reports. You asked Lenovo.
Which? I'm on the other.
Sorry, it's
which page?
internal page 574, bundle page 118. Line 8, this is me cross-examining Professor Valenti. You explained to my lord on Friday and again today that it was between your second and the third reports that you asked Lenovo's lawyers to find some examples of on-off signalling being used in a practical system. So you cannot have thought your exhibit MCV10 had a good example of that, can you? That was the one we just looked at. Well, the example could have been in that document, is the answer. Question, did you not even read your own exhibits before asking for these searches to be done? A, well, this is an entire book. I'm familiar with the book, but I was not familiar or had memorized every part of the book. So you never even realized that chapter 5 of this book, which you had exhibited and which you relied on for a different purpose, might conceivably contain a useful example of on-off signaling being used in a real-world system. I am trying to recall exactly the discussion at the time. Forgive me, as I mentioned before, sometimes it's hard to remember months and exactly when things transpired. I may have seen this before the second report was put in, but it was not included here. It may just have been that I did not feel that we needed the additional example. Let us just break that down. If you thought that your exhibit MCV10 already had a good example of on-off keying being used in real-world systems, why did you ask for more searches to be done? Answer, this is just something with illustrations. This is examples of where this type of signaling has been used. It is not meant to be implied that it's common general knowledge. You know that these specific examples exist. It's just that these are examples of where someone who possesses the common general knowledge has decided to take this approach. Even after the searches were done, you still never referred to section 535 of Homer in your third report, did you? Apparently I did not. And then it goes on to say Willenegger, which is the CTMF 2000, was the example he did give. And these are the searches which Professor Valenti actually asked Lenovo's lawyers to do between his second and third report, referred to by the judge in para 69. Now, Lenovo's lawyers didn't give evidence of the search. We don't know how many thousands of documents they looked for. We don't know what, if anything, the editors out of the search. But as we see from the evidence, Professor Valenti was unable to explain why he needed to ask Lenovo's lawyers to find examples of on-off keying being used for any purpose in cellular network before the priority date, when if what my learned friend is saying today is correct, he could simply have used his own exhibits to his own second report. At any rate, as my Lady Justice Falk pointed out a moment ago correctly, this section 535 is all about a downlink channel anyway. It's a downlink channel used by the base station to transmit positive and negative acknowledgements. And my Lord Justice Birss said, well, was there any evidence about the implications of section 535 so far as considering Samsung? No, there was no such evidence. That's because of the way it came into the case. Professor Valenti never relied on that section at all. Now, my learned friend might be tempted to say that, well, the judge must at least implicitly have found that 535 was common general knowledge, even if it was never deployed for that purpose, in order to reach a conclusion on terminology. But not so, because there's no suggestion, as I said, that either Qualcomm or Motorola papers were common general knowledge, but the judge relied on them for the same purpose. Just what does this mean? Now, one of the arguments my learned friend has when he attempts to suggest that...
Sorry, there is a reference in 62 where it says, published in May 2006, that Dr. Moss accepted that it distilled what the skilled person would have known.
That's an excellent question, because I was just about to go to it.
Sorry.
No, he's given me a splendid peg. My learned friend does rely heavily on that very point about distilling. It was actually my learned friend's word which he introduced into the questions, for no doubt it was carefully chosen. So the issue is really, what did Dr. Moss think my learned friend meant by the choice of that word? Because whether A distills B in a general sense is not the test for whether particular information contained in something is common general knowledge. It's occurred to me, we keep talking about common general knowledge, but Lord Justice Warby and my Lady Justice Falk might have heard of the term without actually hearing what the definition of the term is. It does have a special definition in this area of law. essentially it's information which is generally known and generally accepted by the bulk of those, generally accepted as a good basis for further action by the bulk of those in the art at a particular date. So the key points are generally known and generally accepted as a good base for further action by the bulk of those engaged in a particular field at the relevant date.
And the point of many of those expressions you just used, Mr. Campbell, is that just because something is known, you can show it existed in the prior art, doesn't mean it's common general.
Correct. There's actually quite a nice quote about just because something is known or even well known to a particular witness doesn't mean it's generally known to the bulk of those in the art.
Necessarily.
And one of the difficulties in these cases is that the experts who come to give evidence about this are often very highly skilled, not particularly typical of the bulk of those in the art. So you can't use whether the expert knows as a proxy. But you can turn it the other way around. If the expert doesn't even know it, then it's very unlikely to be common general knowledge. And
But
certainly
your definition has two limbs, generally known and a good
generally
basis.
accepted as a good basis for further action. So my lords and my lady will appreciate that the word distills doesn't appear in the test. Actually, when I first heard this, I instantly thought of whiskey, actually. And it perhaps is useful to this extent. It's produced by distilling water and malted barley. But it doesn't tell you how common the whiskey is or how common the water and malted barley is. It simply tells you one came from the other. And actually, that was about as far as the evidence got. I can show the court what the cross-examination was about distilling. If my lords and my ladies still have the SUP bundle open, it's tab 9, page 108. Page 108 of the bundle, and it's internal page 214 at line 24. Both you and Professor Valenti have referred to scheduling in HSUPA. I just want to make sure we'll go through it. So could we start with bundle D2 tab 10, and that's the same chapter we've been looking at. This is the Holman Toskala book on HSDPA, HSUPA for UMTS, more precisely it's the chapter. This was published shortly after the priority date in May 2006, but I think you agree that this distills what would have been known from the standards at the time. Yes, I am sorry, that would have been known from the standards as of January 2006. So the questions actually put in terms of how both he and Professor Valenti are giving evidence about scheduling in HSUPA, which is true, 556 did have that. And then my learned friend draws attention to D2 tab 10, and I've shown you that Professor Valenti have drawn specific attention to 556. So that's as far as the question goes. The focus of the question was about scheduling in HSUPA generally. We see that from the bottom of page 214. And it would, I accept, be taken to have focused on the particular section on which Professor Valenti relied, which was the bit about scheduling in HSUPA, SI, happy bits, and data rates. But the question didn't ask, do you agree that everything in the book, or even everything in the chapter, is common general knowledge? He didn't even ask him to agree that anything in the book or the chapter was common general knowledge. The question didn't use the phrase common general knowledge at all. It just used my learned friend's slightly odd word of distill. And there's actually a reason for that, which is somewhat oddly, my lords and my lady might think. Professor Valenti gave 3 reports of some length in this case, and he never dealt with on-off keying in any of his common general knowledge sections in any of the 3 reports. I said that in my skeleton arguments, paragraph 28. My learned friend hasn't come back to show why that's wrong. But certainly neither expert gave any evidence that section 535 was part of the common general knowledge, and that was never put. And we can see that Professor Valenti, he obviously couldn't have thought it was a good example, because otherwise he wouldn't have asked for the searches. So the reason we went down here, my learned friend suggesting there's some apparent inconsistency, and I would submit that I've demonstrated there is no inconsistency between para 62 and the judge's findings in para 71. They were relied on. Para 62 is relying on the book for one purpose, para 71 is common general knowledge. But let's assume my learned friend is right. Let's assume there is this inconsistency. He says there is. The learned friend in his paragraph 63 says the judgment should have proceeded on the basis that the skilled person knew, as part of the common general knowledge, that on-off keying had been used in existing cellular networks. I think he's getting that out of, well, you can't get out of CDMA 2000, that's not common general knowledge. You can't get it out of section 535 because that was never said to be common general knowledge. I don't know where he's getting it from, but the judgment should have proceeded on the basis that the common general knowledge included knowledge of on-off keying had been used in existing cellular networks. Well, what then, we ask? Because the judge's finding was that on-off keying was very seldom used in transmitting control information. Should the judge's finding therefore have been of very occasional use rather than very seldom use? Is that the high point of this argument? But as I've said moments ago, neither expert gave any evidence about the implications for obviousness of a Samsung if 535 was part of the common general knowledge, because it was never part of their case, never part of Lenovo's case. But why would there be any such implications? Because Professor Valenti says section 535 is not the best example of on-off keying in the first place, and it's being used on a downlink channel called EH to signal positive and negative acknowledgements. What's this got to do with uplink scheduling messages at all, let alone with a particular scheme being proposed in Samsung? And where is the evidence dealing with such matters? So even if learned friend were right, there's some inconsistency, and I say he's wrong, the point still goes nowhere. Then turn to ground one of learned friend's appeal, having made these preliminary comments. As I've said, this was supported by the 15 lines in the first report, and that didn't actually make it into the appeal bundles until this week. I'm not planning to go there because they are only 15 lines long. It's sub 4B at 53F. The reason I mention that is it's one of our respondents' notice points that you can tell from the fact it only came in the second report, but it's all hindsight. But let's focus on the actual primary case, as it's called. Now, there is an issue between the parties, as there was at trial, about how many steps this primary case actually involves. Now, I have to say immediately, the number of steps is only ever an aid to analysis, because as my learned friend says correctly, patentees have a tendency to suggest there are more steps, and parties attacking validity have a tendency to say there's less steps. And I don't think that comes as a surprise to anyone, and it doesn't really matter how many steps there are, because the question is one of substance, not how many steps there are. Now, we said there was actually 4, and they said there was only 2, and they accept they failed on 2. Sometimes you can wrap them into fewer steps, but can I just show my lords, my lady, Samsung to explain what the 4 logical steps have to be? And for that, we do need to go to Samsung briefly at tab 1. And it all turns on 3.2. And it's really just a few lines. The one about for the uplink situation is a bit different. It's about 7 or 8 Now, options A and B are both set out. And these are both ways in which the mobile can ask for additional uplink capacity. We're now going to subject this to a close textual analysis, which the judge said at para 137 couldn't support. But let's do it anyway, because our friend does do that. Option A is one that Learned Friend says correctly that is available only when the UE, say the mobile, already has a resource allocation on the uplink shared channel. Because you're talking about it's being added. This message, EDCH SI-like message, is added to other traffic for which an uplink resource allocation has been received. So it's already got a link, already got the allocation, and you're just adding this message to something you've already got. And then the point about that is it's really quite an easy thing to do, because the EDCH SI message, forget the like for the moment, go back to HSUPA. What was the EDCH SI message there, the SI message, I'll just call it for short. That's the one which is 18 bits long, had to be decoded. You simply add that message to the traffic on the existing channel. It's very simple to operate A. No real change is necessary. But what about option B? Now, Learned Friend says correctly that option B is the only one that you can use in the situation where the mobile has no existing uplink resource allocation. We accept that, and the judge so found at para 134. But Learned Friend's problem is that Samsung uses the exact same description in each case. It's the EDCH SI-like message in A, and the EDCH SI-like message in B. And Professor Valenti agreed it was a reasonable interpretation. It could be the exact same message, although he went on to say that someone carrying this forward could decide to use something different. But if it's the exact same message in A and B, and the EDCH SI-like message has to be decoded in case A, then why would the same not apply in case B? And if that's right, then Samsung works perfectly well without any of the other modifications required by Lenovo's multi-step argument. And you never get anywhere near the invention. And that's why Learned Friend says that option B is, quotes his words, a similar form of message. But that's rewriting it. It doesn't say in B you can use a similar form of message. It says an EDCH SI-like message. So you've actually got to decide to do something different with the EDCH SI-like message in A and B. And that brings us to Learned Friend's, he says it's his first step, we say it's his second step. This is the one about reducing the 18-bit message to a single bit. Now, Learned Friend, he talks about trade-offs and so forth. It's important to remember the patent has no requirement whatsoever that the transmission burst be a single bit any more than it requires 18 bits. So there is no trade-off between a single bit and an 18-bit message so far as the patent is concerned. So the only reason...
It's more that it would work on the concept would work.
Yes, the concept would work because you're using the presence of the message, whether it's 1, 18, or 500, or any number of bits you like. You're using the presence of the message as an indication of a schedule. So why are we having all this about 18 and 1 bits? Well, it's not because of anything in the patent, as I just demonstrated. It's because of an inherent weakness in Learned Friend's primary case. And the inherent weakness was that in those 15 lines in the first report, the only reason Professor Valenti originally gave for modifying Samsung, so as to detect the transmission burst by its presence rather than by decoding its content, depended on first modifying Samsung from an 18-bit message to a single-bit message. But that was an artifact of their argument. It had nothing to do with the patent. Professor Valenti, at least, seemed to think that going from 18 bits to 1 bit made the next step in easier. But the whole debate only arose in the first place was because the primary case is so complicated. It's got all these extra steps in it. Why do you need the 18-bit to one step? Answer, because, as I say, they felt they had to go via 1 bit to get to the detecting presence integer. And it was only
sorry, just to make sure I'm following this, Mr. Campbell. Presumably the point is that once you've gone from 18 to 1 bit, you're thinking you only have to send 1 bit of information. Then the argument is, it then occurs to you that you could use on-off keying to only send 1 bit of information.
That's the way the argument was put, yes.
Right. Whereas you could use on-off keying to send 18 bits of information, but that would be 18 bits of on-off keying.
Yes, which is why it only popped up in the second round of evidence. Yeah. Oh, hang on, yeah, I could do that. But that was the way it was put, because and the problem they had with that, of course, was on-off keying was still at the back of everyone's mind, whether you had a single bit or 18 bits. So that's why they had the same problem, as the judge says, whether on the primary or the secondary argument. You never get as far as detecting presence. But anyway, the answer to Lord Justice Birss's question is yes, that was why they did that. So it was only really when they got a bit more hindsight in the second argument, they thought, well, in the second round of evidence, well, let's cut out the 18-bit to 1 bit, and let's just detect the presence of the 18-bit. But that wasn't something that occurred to them in the first place. And then there's a few more steps as well. My friend did allude to them. The third step is to use a message interpreter that's physical, whereas the EDCH SI message and HSUPA was interpreted at the MAC layer. That was one of the more technical points this morning, but I'll try and summarise what my learned friend said. They have all these layers in mobile telecoms so that different teams can work in different aspects of the city. And the physical layer is the bottom one, which goes across the airwaves. The MAC is a more complicated one, which is used in constructing and deconstructing the message. And the point about the patent is it's actually at the bottom layer, the physical layer, whereas the EDCH SI message and HSUPA was at the MAC layer, which is higher up. And it's because it was at the MAC layer, it always had to be decoded. But however Lenovo does it, whether it's primary and secondary, he still has to get over the barrier of using a presence of a burst on the physical layer as the indication of the scheduling request. Now, Lenovo, his first point in his grounds of appeal, and he did advance it orally, was the point about any stated advantage of the patent. That's his submission, ground 1A of his appeal, that a patent has to state the advantage. Well, that's inconsistent with Medimune, of course, which I cite as one of my first authorities. The obviousness is a single and relatively simple question of fact, namely, was it obvious to the skilled but imaginative addressee reading Samsung to make a product or carry out a process falling within the claim? That is the only question that has to be answered. Now, I do accept that whether or not there is an actual advantage of the claimed invention is something that can, in principle, be taken into account in answering that question of fact. Because if there is an actual advantage, particularly one which was known to the skilled addressee and which was taught at university, it can be relevant to ask why the claimed invention wasn't done before or taught by Samsung. And the simple answer to that is that, well, it wasn't obvious at all. But we certainly don't see why anything at all can turn on whether or not the patent happens to state the advantages of the invention. And the judge actually dealt with this in the passage we respectfully adopt. It starts at para 113 of the judgment, page 96. In closing, Lenovo made a great deal about the absence from the patent specification of any stated advantage of the inventive concept advanced by InterDigital trial. We do have a respondent's notice point about this, actually, which was that it was only raised in closing. And the point there is that the case would have been really very different if no one had to face this. We would have had evidence talking about stated advantages, the terms in which it's stated, why was this or that stated. It was an ambush in closing. But let's look at the substance of it, because, as the judge says, no statutory requirement that the invention claimed in the patent provides an advantage over the prior art, i.e. any advantage at all. If it does not, generally the invention may well not be used by third parties, in which case the patent will probably not trouble the courts, but that's by the way. My learned friend accepts that the judge is right about this. He's not challenged that. It's certainly the case that a valid patent has to be new, inventive, capable of industrial application, satisfying all other requirements. But there's no freestanding requirement for any advantage at all, far less a statement of the advantage to appear in the patent anywhere. And one of the points my learned friend made in his written submissions, it wasn't pressed to be fair, he talked about the general principle of a patent monopoly should correspond to the technical contribution to the art. Yes, but that is answered using the relevant statutory questions, not using some freestanding joker card in which we can just apply some different tests. But as I say, he did accept, and he showed my lords and my ladies some evidence to the effect that there is an actual advantage in the patent. So, insofar as there's some suggestion that there's a requirement for a stated advantage, well, how does that arise? The judge dealt with that too in para 115. A patent specification may set out a problem with the prior art technology, identify a solution, explain why the invention embodying that solution is improvement of the prior art. There's sometimes nothing may be said about any advantage, and using the inventive concept as advanced at trial. One possible inference to be drawn is that between the drafting of the specification and the trial, patentee's idea of what the inventive concept is has moved on. The learned friend positively accepts that the skeletons this is correct. Now, if it's correct that a patent doesn't have to state an advantage, that must be the end of ground 1A of the grounds of appeal, because that was the point there. Now, my learned friend did make some other submissions, not, I think, entirely under the heading of Group 1A. Sorry, grounds of appeal 1A. I think it's more under 1C, but I'll deal with them anyway. And one of them is the principle he extracts from Horn Engineering. And he did refer my lords and my lady to that. I don't think he actually showed it to you. I will show the quote that one, just so we know what we're talking about. I'll be fairly brief thereafter. Horner's Authorities 2, paragraph 14. Sorry, it's page 29. Yes, it's paragraph 14 of the judgment. It's a principle that's often cited in these type of cases. Lord Justice Aldous said, in order to establish whether something is common general knowledge, the first and more important step is to look at the sources from which the skilled addressee could acquire his information. I would add that though it has to be remembered that a specification may or fail to provide specific details for the addressee to understand and apply the invention and still be insufficient and invalid, it is often possible to deduce the attributes which the skilled man must possess from the assumptions which the specification clearly makes about his abilities. Now, the way in which my learned friend puts the argument is he talks about a toolkit, and he also suggests, well, let's show what my learned friend actually says, because I believe he said the same orally as he said in his written. It's my learned friend's paragraph 42, core 2, tab 27. What my learned friend says here is first sentence, needn't worry about. Second sentence, I've shown the quote, Horn Engineering. And then it's this last sentence. In this case, the patent, specifically para 37, treats the use of a transmission burst as part of the skilled person's toolkit that he would use. So that's what my learned friend's done there. He's put the word would in there. Would use, with without further explanation or assistance. And that's how the prior art should have been approached. Now, in fact, the argument isn't quite right anyway. It's not just a transmission burst, it's a transmission burst where the presence of the transmission burst on a particular channel indicates the request. But the greater flaw is the way in which Malone and Friends seeks to equate could with would, which is not something he gets out of Horn engineering. Now, our submission is the basis on which the judge approached the prior art is that the skilled addressee could have implemented a method which worked by detecting the presence of a transmission burst as being indicative of a request for uplink transmission resources. But the ability to do so, the could, had been true in cellular systems for a long time. The problem with Lenovo's case and the difference with the prior art is that Samsung didn't suggest the skilled person would use such a transmission burst. Now, I don't want to suggest that could versus would is a replacement for the statutory test. It's a way of explaining the statutory test. But the reason why it was not obvious was Samsung didn't suggest, teach, or hint at using a transmission burst. So when Malone and Friends says the prior art should have been approached on the basis that transmission burst is something the skilled person would use without further explanation or assistance, that's not right. It should have been approached and was in fact approached by the judge on the basis that it's something the skilled person could use without further explanation or assistance. But the judge's construction of the claim, going back to para 100, is that could's not enough. The method actually has to do it. Now, Lord, I was going to come on to Poxolian prejudice now. I'm allowed to have enough for quite a long day.
So what's your estimate, Mr. Campbell? Bearing in mind, I think this case is listed for a day and a half.
Day and a half, yes. I think I'm going to be another hour.
Okay, and that's enough time for you, Mr. Hitchcock. Very well. Let's rise and sit again at 10:30.